Hello, students. Welcome to Political Science 475, Constitutional Law. Today's lecture is very broad, and it's kind of philosophical in nature. We won't be going over a lot of particular cases. We will kind of be laying the groundwork for how the Supreme Court has approached the Equal Protection Clause in general. Before we get started, let's talk about a couple things. So far in the course, we've been talking a lot about your civil liberties, freedom of speech, press, religion, assembly, right to petition government for a redress of grievances, a lot of your civil liberties that are defended by groups like the ACLU, right? The American Civil Liberties Union. They were set up initially to defend free speech rights. Now we're turning to the Equal Protection Clause, and we're dealing more with civil rights. So what is the difference between civil liberties and civil rights? A lot of the time, Americans just treat them together, right? And say, oh, your civil liberties, your civil rights. What's the difference? Actually, there are important differences. What's the difference between your civil liberties and your civil rights?
I do not know.
You don't know? All right. Well, your civil liberties are your freedoms. Your civil rights are your guarantees of the equal protection of the laws, right? So the 14th Amendment says no state shall deny any person within its jurisdiction. Well, no state shall deprive any person of life, liberty, or property without due process of law. That's a due process clause. Nor deny to any person within its jurisdiction the equal protection of the laws, right? So your civil rights are your guarantees of the equal protection of the laws, right? So I want to make sure that we're all clear on that. There's the difference between civil liberties and your civil rights. Now let's discuss the word discriminate for a minute. When people use the word discriminate, does it usually have positive or negative connotations?
Negative.
Negative connotations, right? I've been discriminated against, right? When people use the word discriminate that way, what does it mean? I've been discriminated against.
Excluded.
Excluded or disadvantaged in some way, or denied some opportunity that's been given to others, usually because of some reason that is beyond my control, or is unfair, or is just spiteful, right? So that's what we mean by discrimination a lot of the time. And used that way and in that context, it has a lot of negative connotations, right? There are different ways to use the word discriminate. Like a lot of words, it can have different meanings, different connotations depending on context and how it is being used. So there's a much more neutral way of using the word discriminate, which is comparable to the word distinguish, right? And so, do we have a lot of laws that distinguish between people on the basis of age?
Yes.
Yes, absolutely.
You have to be 16 to drive by yourself. You have to be 18 to vote, 21 to drink.
That's right. We have a lot of laws that distinguish on the basis of age. Absolutely, right? So, if you're 15 and you can't drive yet, if you're 17 and you can't vote yet, if you're 20 and you can't buy liquor yet, are you being discriminated against?
Yes.
Yes, actually you are, right? So, now you're starting to get a kind of the difference, right? Do you think that discrimination is fair? Do you think it's fair to distinguish between a 15-year-old and a 16-year-old when it comes to who can drive, a 17-year-old and an 18-year-old when it comes to who can vote, a 20-year-old and a 21-year-old when it comes to who can drink?
Well, personally, as a person who cannot drive by themselves, I have a very different perspective.
Sure, I'm sure you do.
Yes.
Right?
So I think it's a little bit unfair to cross to, like, it's such a broad thing, like, no one. And I'm like, well, I think I would be perfectly capable to vote. I think I'd be perfectly capable in, like, 2 more months to drive by myself to school.
Right.
So that I can, like, drop off something. That, I think, is something that's reasonable for me to do. So I think it's a little bit unfair whenever they cast, like, just law that just applies to this and no exceptions, because I think that there are general exceptions and you can't just say no to everyone just because of their age.
So you feel you are being discriminated against?
Yes, I feel that I should be able to drive by myself.
Yeah. Yes.
Most 16-year-olds aren't smart enough to make their own voting decisions. Their parents can just tell them who to vote for, and they would. They can just take away their phone.
No, that's a good...
There's no way for them to know who they voted for. This is a blackmail for crying out loud.
Just take away your phone if you don't... I like that. I've never heard that one. That's really original. Okay, so anyway, the answer is to are you being discriminated against is yes, you are. The question becomes then, is that discrimination constitutional? And it all comes down to how the Supreme Court has interpreted the Equal Protection Clause, right? So, guess what? So, Natalie, you're 15.
Indeed I am.
And you can't drive on your own.
Boo.
Boo. The court has said age, right, is a non-suspect classification. Non-suspect classification, right? So if someone tries to make an Equal Protection Clause claim, I'm being discriminated against, I'm being denied the equal protection of the laws, the first question the court will ask is, okay, on what basis are you being discriminated against? And in the case of you can't drive until you're 16, on what basis are you being discriminated against?
Age.
Age, absolutely. This is age discrimination. Yeah, you're right, it is. Okay, so let's ask some questions about age. Are there genuine biological differences between a 2-year-old and a 16-year-old?
Yes.
Yes. Why do we allow 16-year-olds to drive and not 2-year-olds?
Because they are capable and they have enough, like, mental capacity to do so, and they can actually work the machinery
and reach the pedals.
Yeah.
Oh, there you go. Okay, now, so question number 1, are there important biological differences between a 16-year-old and a 2-year-old?
Yes.
Yes. Right? Yes. Keep that in your mind, right? Question number 2. I'm older than you are. I drive, right?
What? Really?
I enjoy, I'm older than you. I enjoy the pleasures of driving. It's wonderful. The freedom out on the open road. It's wonderful. Okay. Have I been 2 years old?
Yes.
Have I been 15 years old?
Yeah.
Do I know what it's like to wait for a driver's license?
Well, yeah.
Yeah. Have I been 16?
Well, yeah.
Yeah. Have I been 40?
Yes.
Will I soon be 50?
Mm-hmm.
Will I, if I live long enough, will I one day be 65?
Maybe.
Maybe. Guess what keeps me, just human nature being what it is, guess what keeps me from persecuting 65-year-olds?
The fact that you will one day be one.
I will be one day. Absolutely. Guess what keeps me from persecuting 2-year-olds?
You've been one.
I was one, right? I was 2. I was 15. I was 16.
You guys want to persecute
Well, okay. Now here's the thing. Human nature being what it is it human nature to be sympathetic toward groups that you were once a member of?
Well, yeah.
Yes, it is. I was 2. I was 15. I remember how exciting it was to get my license once I turned 16. I remember how exciting that was, right? Am I gonna, terminate people who are 65? No. Why? Because I will be one day, right? So, in other words, is your age something that is present at birth and persists throughout your life? Are you always 0, or does it change?
It changes.
It changes. Is there a possibility that you will, actually with age, because it's just a biological fact, will you find yourself in different age groups as you age?
Yes.
Yes. So, again, I will ask the question again. What keeps me from persecuting 65-year-olds?
You will be one day.
I will be one day. Absolutely. Right? Okay. Now, let's ask, actually, that's enough for age. Right? Genuine biological differences. Important. There's a lot of importance in the fact that you were certain ages, you'll be certain ages. So, the court, for 14th Amendment Equal Protection Clause purposes, has found that age is a non-suspect classification. Right? Sorry. So, you can file your lawsuit, but you're not going to win. So, in this situation, the court will apply what is known as the rational basis test. Right? When you're over there on that end of the continuum, the court will apply the rational basis test. And the court will ask, is the policy a rationally related? Sometimes it'll use the word legitimate. Sometimes it'll use the word valid. Means. So is the policy a rationally related, legitimate, or valid means of accomplishing, and this is where it gets. A valid or legitimate government objective, right? So can you see that? So, making people wait until they are 16 to get a driver's license. And I know this is hard for you, right?
Well, okay.
But hey, this is for the class, not you. All right, making you wait until you're 16. What's the government objective? Why do we make people wait until they're 16? Why don't we let them start driving when they're 2?
Because
Government objective.
Government objective to make it safer for
Safety.
Yeah.
Safety. I hate to cut you short, but the reality is safety is always going to be a legitimate government objective. As a matter of fact, as we'll see later, it's going to be even more than legitimate. It's going to be a compelling government objective, right? Are we now under quarantine?
Yes.
Why?
Because of the corona.
And what's the government objective?
Safety.
Safety.
For everyone else.
Right. It's a compelling government objective. It can justify all types of government intrusions. But anyway, there we are. So, making people wait until they're 16 to get a license. Is that rationally related to the government objective of safety? Are 16-year-olds in general better drivers than 2-year-olds?
Yes.
Yes. Right? So it's rationally related. It's not perfect, right? But when you're down here dealing with a non-suspect classification, and age is a non-suspect classification, then the court will apply the rational basis test, and they will just ask, is this policy at least rationally related to a legitimate government objective? And if it is, then it will uphold the policy. So do we have all kinds of laws that discriminate, that distinguish on the basis of age?
Yes, we
Yep,
do.
absolutely. Right? Now, a couple things also to keep in mind. Some scholars also do this. I like looking at this as well. It's important to keep in mind that when you're dealing with a non-suspect classification, the burden is on the individual to show that the policy is not even rationally related to a legitimate government objective, right? If the individual cannot make that argument, then who will the court rule for? The individual or the state? The state, exactly. So the burden's on the individual to show that the policy is not even rationally related to a legitimate government objective. Otherwise, the default approach the court will take is to rule for the state, to rule for the government. Right? Any questions on that?
No.
Okay, now, let's discuss an age classification now. That's kind of interesting. Now this may have changed, and I think it has a little bit. But for a long time, commercial airline pilots had to retire at 62 years old. Right? Yeah, commercial airline pilots. And that was an FAA regulation, and that's a government entity, right? So they pass a regulation that carries the force of law, and pilots, you can't be a commercial airline pilot. I think it was like after 62, right? Okay, well, does that policy distinguish on the basis of age?
Yes.
Yes. Does it discriminate on the basis of age?
Yes.
Yes, it does, right? Question becomes, is that rational? Is that acceptable? Is that constitutional? Is that appropriate? Okay, so say you're older than the age limit, you're a commercial airline pilot, you don't want to retire, you file a lawsuit, you say, I'm being discriminated against, right? And you're right, you are. You're being discriminated against. The policy clearly discriminates. The question is that policy constitutional or not, right? Goes to the Supreme Court, and what is the first question the court will ask?
Classification.
What classification are we dealing with? And what will your attorney have to answer? Age, right? And whether you have a good attorney or a bad attorney, guess how the court's going to approach this now? That test. Can ask that test. Say, okay, well, with age discrimination claims, we apply the rational basis test. What's the government objective here? Why are they forcing pilots to retire at a certain age?
Safety for passengers.
Safety, absolutely. Right? The older pilots get, do their reaction times slow down?
Yes.
Yes. Are they more likely to have heart attacks or strokes?
Yes.
Yes. Is that a concern when you're operating a commercial airliner?
Very much so.
Very much so, right? So is this policy rationally related to that objective, that safety objective?
Yes, it is.
It is. Again, is it perfect?
No.
No.
But nothing ever is.
Well, there you go. And that's the thing, is when you're trying to make an age discrimination claim, good luck, right? Because the courts can apply this framework, and as long as the policy is even rationally related to a legitimate or valid government objective, then the court's going to uphold the policy. So, do we have all kinds of laws that discriminate on the basis of age?
Yes, we do.
Yes, we do. All right. So now we've gotten age discussed. Let's discuss another classification that the court has said is a non-suspect classification. And that is income. Right? Okay, so let's ask different types of questions. Let's see. This is one of the things I love about the Equal Protection Clause is the court has asked different questions in different cases depending on the type of the classification that you're dealing with. And sometimes they ask unique questions. Sometimes they ask similar questions. And you start to get a feel for how the court thinks, right, when it comes to the Equal Protection Clause. So let's ask some questions about income. Is income a trait which is present at birth and persists throughout your life? Will you always be of the same income category, or will your income change?
My income will change. Right now, I am broke.
Yeah.
I hope one day not be that way.
Okay. Very good. People tend to vote their aspirations, but we'll talk about that later. But the point here is, so, you know, I earn a decent salary now. No complaints. I earn a good salary as a college professor. Is it possible I could win the lottery if I, bought tickets from Georgia or Tennessee or one of our neighboring states? Is it possible I could win the lottery and be a millionaire tomorrow?
Yes.
Yes. So, guess what keeps me from supporting really high tax rates for the wealthy?
What?
Well, I could be wealthy one day.
Oh.
Yeah.
Now keep telling yourself that.
Yeah. Guess what keeps me from persecuting those who don't have a lot of money?
You could be one of those one day.
I could be one of those there, but for the grace of God go I. Right? So, you be wealthy one day, you could be poor one day. Are people going to be in different income groups throughout their lives?
Yes.
Probably, and again, now's not the time for the discussion of, social mobility in our society. I understand some people think we don't have a very socially mobile society, and that's a concern in our democracy. If your parents are wealthy, you tend to be wealthy.
Well, yeah.
Yeah,
People who are wealthy tend to be in power.
Yeah, I know, exactly. Now's not the time and place for that. We're dealing with how the Supreme Court has approached income as a classification, and they have said it is a non-suspect classification, right? Because it's not a trait which is present at birth and persists throughout your life. you could find yourself in other groups, right? Make sense? So that's kind of what they have said about income. So, what test will they apply?
This one.
Yep, the rational basis test. And so, if you look at progressive income taxes, do we tax it on our federal income taxes, not so much our state? On our federal income taxes, do we tax the wealthy at higher rates than we do those in lower income tax brackets?
Yes, we do.
Yes, we do. Absolutely. What's the government objective? Why do we do that? Why do we tax the wealthy at higher rates?
Because they can afford it.
They can afford it. You go where the money is, right? We need to generate revenue as a society that the government can spend on worthwhile government projects, and you go where the money is, right? So that's a legitimate government objective. Does Congress have power to tax and spend for the general welfare?
Yes, they do.
Yes, they do. And the Supreme Court has said Congress's power to tax and spend for the general welfare is very broad, right? So, we have progressive income tax structure. It's trying to accomplish the legitimate government objective of raising revenue for government. Is a progressive income tax structure rationally related to the government objective of generating revenue?
Yes.
Yes, it is. Absolutely. So, is the court going to uphold or strike down progressive income tax structures?
Uphold.
Uphold, and that's why we have them. Exactly. Right? So, do we have all kinds of government programs and policies that take income into account when determining when you're eligible for them?
Yeah.
Absolutely. And are you being discriminated against if you're in a certain bracket some of the time?
Yeah.
Yep.
We don't care.
Well, it's not that we don't care. It's just that's the way the court approaches income. It's you're being denied the equal protection of the laws. If you're very wealthy, you're paying a higher tax rate than those who are not as wealthy, and too bad, right? Because the policy is rationally related to a legitimate government objective.
Yeah.
Make sense?
Yes.
Yeah. Okay. Now, let's go to the other end of the spectrum now and look at race. Okay? Race is at the other end of the spectrum here, right?
Mm-hmm.
And the court has said race is an inherently... Whoops, went on to my other page. Inherently suspect classification. What does it mean to say something is inherently suspect?
I do not know.
Inherently means by its very nature.
Ah, that's right.
Right? So, race is an inherently suspect classification. And let's start asking some of the questions why that the court has asked in the case of race. Other than skin color and hair texture and eye shape and a few other other superficial, trivial differences, are there important biological differences between different racial groups?
No.
No. Are like I said, other than skin color, eye shape, hair texture, other very superficial things, a human being is a human being, right?
Yeah.
Now, unfortunately, throughout history, those superficial racial characteristics were used to justify treating people of certain races very horribly, right? But as far as the court is concerned, where we are now as a society. Incidentally, as we're discussing all this, we're talking about where the court is now. We'll look at different rulings in different areas later. But we're talking about where the court is now. The court says now that any policy that distinguishes on the basis of race is inherently suspect. Right?
Right.
That's right. And so, again, are there important biological differences between different racial groups?
No.
No. Right? So, we saw there were important differences between a 16-year-old and a 2-year-old, right? And that's why a 16-year-old could drive and a 2-year-old couldn't, right? But you wouldn't say the same thing about people on the basis of race.
No, you would
right?
not.
No, you would not. Okay, next. Is race a trait which is present at birth and persists throughout your life?
Indeed, it is.
It is, right. So will I wake up tomorrow and find myself Hispanic?
No, you will not.
No, right? Again, unfortunately, human nature being what it is, are people more likely to persecute groups that they know they will never be a member of than they are groups that they might be a member of one day?
Never be a member of.
Never be a member of, exactly, right? So, unfortunately, human nature being what it is, if I know my race is never going to be changed, unfortunately, some groups will be less sympathetic toward other groups, right? Because you know you're never going to be a member of that group, right? So next, have certain racial groups been historically disadvantaged in our country? Have they been denied? Yes, they have. Have they been denied certain fundamental rights or opportunities?
Yes.
Yes. What were some of those fundamental rights?
Voting.
What were others?
Owning property.
Freedom.
Ability to marry whoever they wanted to marry.
Exactly. Those were fundamental rights that were deprived. So, you look at those, all those things that we looked at. There's another one. Like I said, there's so many cases. I've read so many. It's not like I have a list I specifically go down every time I give this lecture. I'm more just go off, cases I think of what I recall. So race, is it immediately apparent when you first see someone?
Yes.
Yeah, usually, right?
Good vision.
Usually, right? So again, unfortunately, human nature being what it is, if a racial minority comes in for a job interview, is it possible that they will not get the job just because someone does not like that racial group?
Yes. Yes.
It's immediately apparent upon first meeting someone. Now, since we have time for this, let's, again, since we're in no rush and this is kind of more philosophical today, and we're not looking at a bunch of specific cases today, we're broadly looking at how the court has approached the Equal Protection Clause. Let's talk about this one for a minute, because the court does. Say you're Jewish.
Okay.
Right? And I don't know it. Right? And you come in for a job interview, and I give you the job, and you work for me for 30 years, and you're the best employee I've ever had. Right? And I'm giving you a retirement party, and you've never brought your religious beliefs up for 30 years.
Even when I didn't get Hanukkah off?
Well, yeah. Yeah, you didn't bring it up for 30 years. You just worked diligently. I think the world of you, right? And then, after 30 years, I find out you're Jewish. Right? Okay.
Do you feel betrayed?
No. See, that's the thing is maybe say I didn't feel one way or the other about Jews before I hired you, right? Mm-hmm. But then you're the best employee I've ever had and you've worked for me for 30 years. How am I going to feel about Jews after that? Positively. See? And that's a fascinating dynamic, right? Because unfortunately, human nature being what it is, if we're prejudiced against a group, then we don't like them to begin with, and we never go through that process, right? But if a group can hide, I don't want to say hide necessarily, but if their religion or their race or their gender were not immediately apparent, then you could just learn to like them first and then later find out, oh, they're a member of some group, and your opinions would probably change about that group.
Yeah.
Make sense?
Yes, it does.
So unfortunately, because race is so readily apparent, people never really go through that learning process. Make sense?
Yes.
Yeah. Like one of my favorite students ever, just a great student, we were talking, I think it was constitutional law. I think when she was taking me for constitutional law, and it may have been in this exact lecture. I don't know.
Whoa.
but it came out, she was Amish. And again, I had no idea, right? Because she'd never brought it up, never come up. And again, it was one of those things I felt, I was impressed by her, and consequently felt more highly about the Amish in general. Make sense?
Yep.
Okay. The next thing about race are certain racial groups, as the court puts it, discrete and insular minorities. Are they less than 50% of the population?
Yes.
Yes, right? So unfortunately, in a democracy, will democratic processes sometimes be used to disadvantage certain minorities?
Yes.
Yes, it's kind of just one of the problems inherent in a democracy, right? So, back in Caroline Products, footnote number 4, the court said, again, we're getting out of the economic cases, and they said, from here on out, we have a special responsibility to protect discrete and insular minorities. Because is the President of the United States elected by the people?
Indeed, he is.
That's right. Our state legislatures and Congress elected by the people.
Indeed, they are.
Yes, and you in general need majority support in order to win.
Yes.
Yes, right? And so the court said it's up to us to protect discrete and insular minorities. Certain freedoms are put beyond the reach of majorities. Right? So, what is meant by the word discrete in this context? Don't know.
Can you read it again?
Yeah, sure. Court has special responsibility to protect discrete and insular minorities.
Not apparent.
Discrete? Good guess. No, discrete means they are set apart. They stand alone. They don't just flow into everybody else, right? So discrete numbers are numbers that are able to stand on their own, right? They don't just flow into another number, right? Okay, so what does insular mean? Vocabulary day.
Yeah,
What are they teaching you guys in public schools? Insular.
They taught me.
Insular is from the Latin word for island, and so they're kind of like the image that is evoked is one of a group of people that kind of stands apart and alone, like on an island. Discrete and insular minorities, right? So are the Amish a discrete and insular minority?
Yes.
Yes. Are they going to need their religious freedoms protected?
Yes.
Yes, right? Are Orthodox Jews a discrete and insular minority?
Indeed.
Indeed. Are African Americans a discrete and insular minority?
Indeed.
Yes, exactly, right? So, certain religious groups, certain racial groups are less than 50% of the population and consequently are going to need special protection from the courts. Any question on that?
Nope.
Okay, so we have determined race is an inherently suspect classification for all the reasons that we specified. So the court will apply strict... I keep running on.
Way to go, Carl.
Yeah, I keep running on to the next page. The court will apply what is known as strict scrutiny, right? What does it mean to scrutinize something?
Judge.
To look at it very closely.
Yeah.
Yeah, and perhaps judge. Yeah. Yeah. But to scrutinize something means look at it very closely. And so, basically, any policy that discriminates on the basis of race, is the court just going to kind of assume it's okay, or is it going to take a really hard look at it? Really hard look, exactly. And they are going to say any policy that discriminates on the basis of race must be the least restrictive, and sometimes in some cases, they'll also say narrowly tailored. Least restrictive or narrowly tailored means of accomplishing a compelling government objective. All right. So, let's look at... actually, let's just look at race-based preferences in college admissions. We'll talk more about these cases later. We'll talk more about the case later, but really quickly, University of Michigan took race into account at both the undergraduate level and to go to their law school. The undergraduate level we'll talk about later, but the graduate level was more important. They upheld using race as an admissions criterion to deciding who gets into law school or not. So that means because they upheld using race as an admissions criterion, that policy survived strict scrutiny, right? So government objective had to be compelling. Why would the University of Michigan Law School need to take race into account when assembling its incoming class?
Because they're underrepresented in the population as a whole.
Okay. Now that's a good argument. The thing, though, is the court doesn't like that argument because that smacks of quotas and proportional representation, and the idea that a certain group is entitled to a certain amount of representation. Yeah.
Well, I didn't like it either. You asked my argument.
Yeah, okay.
There it is, and it was a good one.
Yeah, it was a good one, but the court doesn't like that one so much. Yeah, we'll revisit those later. You guys say because diversity in legal education is a compelling government objective. Educational diversity. And we'll see how that evolved again when we get to the cases. But the court has said educational diversity, given our nation's history, and given the educational opportunities that were denied to certain groups, educational diversity is a compelling government objective. And the way the law school was admitting people, they were using a holistic approach. They looked at the entire application, and then they used race as a plus factor. They said that was a narrowly tailored way of accomplishing the compelling government objective of educational diversity. Make sense?
Yes.
All right. So that's where we are, race. And we'll look at a bunch of cases dealing with race. And like I said, this is where the court is now, right? It took them a while to get there, and we'll see the cases that led up to there. Now, one further point to make sure that we're entirely clear on this. If someone challenges a policy that discriminates on the basis of race, who will the burden be on to show that the policy is not acceptable or constitutional?
Government.
Yeah. Well, I kind of worded that poorly. The burden is on the government to show that the policy is the least restrictive means or a narrowly tailored means of accomplishing a compelling government objective.
Okay.
If the government can't make that argument, then what will the Supreme Court do?
Strike it down.
Strike it down. Exactly. Excellent. Right? So the burden's on the government whenever a policy that distinguishes on the basis of race is challenged. The burden's on the government to prove that it is the least restrictive means or a narrowly tailored means of accomplishing a compelling government objective. Otherwise, the policy will be struck down. Outstanding. Excellent. Okay, so you see, we've been to the left of the spectrum, the right of the spectrum. What's obviously missing? Gender. Yeah, there you go. All right. So, gender. Let's put it right there in the middle and start asking some questions. In general, and I'm just going to use the word gender because the court does. It doesn't keep up to date with the latest changes in terms. Gender, sex, sexual identity. Is your gender a trait that is your sex a trait that is present at birth and persists throughout your life?
Yes.
Yes. So is gender kind of like race in that regard?
Yes.
Yeah. Is your gender usually readily apparent when you first meet someone?
Yeah.
Yeah.
Most of the time.
Most of the time. Again, yes, usually, but sometimes there are situations where that's not the case, but usually it's readily apparent. So again, is it similar to race in that regard?
Yes.
Yes. Have women been historically disadvantaged in our country?
Yes.
Yes. Have they been denied certain fundamental rights?
Yes.
Like what?
Right to vote, right to own property,
Very good.
Right to inherit certain things. What else?
Yeah. So in all those ways, are they similar to race?
Yeah.
Yeah, and would kind of be down toward that end of the continuum. But now let's ask some other questions about gender. Are women a discrete and insular minority? Are they less than 50% of the population?
Nope, we're about 50-50.
Yeah, it's about 50-50, and actually a little more, because women live a little longer. They engage in less risk-taking behavior. that type of thing. Yeah. So the point is, if women voted as a block for female candidates, would females hold almost every elected office in the country?
Yeah.
Yes, they would, right? So actually, even though they've been historically disadvantaged, and the effects of that have taken a long time to overcome, the reality is women are still a majority, right? That means the democratic process is available to them. So are women a discrete and insular minority?
No.
No, they're not. They're not, right? So would that make them more like race or more like age?
More like age.
More like age, exactly. Let's ask another thing about gender. Are there important biological differences between men and women?
Yes.
Yes, right? Can only women give birth?
Yes.
Yes. Do women in general lactate and nurse newborns?
Yes.
Yes. Are these just biological facts?
Yes.
Yes, right? So, in those ways, men and women are not the same, right?
Yes.
Consequently, there are important biological differences between men and women, especially when it comes to reproductive issues, right? So, where is the court going to place gender? In the middle, right? And it is going to say that it is a quasi-suspect classification. What does quasi mean?
I don't know.
Really?
Spelled Q.
Yeah, it means kind of.
Ah.
So it's kind of suspect. A little bit. Ish. You know, so if you have a policy that distinguishes on the basis of gender, is there a possibility that it's an appropriate policy?
Maybe.
Yeah, there's that possibility because there are genuine biological differences between men and women, right?
Yes.
It's true. All right, so the court will apply intermediate scrutiny, kind of right in the middle, intermediate scrutiny, also sometimes called heightened scrutiny, right? So what does heightened mean?
Hyper.
Well, heightened means you're going to take a little closer look at it than regular, right? Than you would under the rational basis test.
Yes.
But not as much as you do when you apply strict scrutiny. So, the court is going to say, and we'll see how these emerged again. If you have a policy that distinguishes between men and women, it must be a substantially related means of accomplishing an important government objective. Okay, and again, we will revisit in the cases how these evolved, right? When we look at gender discrimination cases. But this is where the court is now. So if you have a policy that distinguishes between men and women, then the court will apply intermediate, or sometimes called heightened scrutiny. I don't have space on here to write it down, but intermediate or heightened scrutiny, and it will ask, is the policy a substantially related means of accomplishing an important government objective? Not just legitimate or valid. It's got to be an important government objective, right? Which is higher than valid, but not as high as compelling. Make sense?
Yes.
Now, the big question that came up in this case is, well, in the cases that we're going to look at, they evolved, who is the burden on? And actually, the court decided the burden's on the government to show that the policy is a substantially related means of accomplishing an important government objective. Otherwise, the court will strike it down. So the burden's on the government. So is that a victory for women's rights advocates or a defeat?
Victory.
It's a victory, yeah. So any policy that treats men and women differently, that discriminates on the basis of gender, that distinguishes on the basis of gender, it's up to the government to prove in court that it's a substantially related means of accomplishing an important government objective. Make sense?
Yes.
Okay, and that's how the court has approached this. Okay, now, we've actually done the plenty of time. So I guess we better end there. Yeah, and sure, bring July around. Our little dog is getting a cabin fever here, and you can see our little dog.
July, look at the camera.
Yeah.
Ow.